in relation to this bill, it's been guillotined through the door, right? And we now find ourselves dealing with it in this House. And there are provisions in this bill which the Minister's officials, and I'm talking about section 126, which is an integral part of the border procedure the border procedure aspects of the Migration Pact, and Section 126 is part of the asylum border procedure, and we've been told that this bill is going to dramatically change and accelerate the circumstances in which asylum applications are dealt with. But you know, unless Ireland is in a position to actually operate the asylum, the border procedure, this bill and our adherence to the Pact is, by virtue of the Common Travel Area, almost set at naught. And what I'd like the Minister to explain to the House is how the asylum border procedure will operate in Ireland. Who will be caught by it? Is it somebody at Carrickardon in County Louth crossing the border? Or is it somebody who appears in Dublin and claims asylum? When does the asylum border procedure actually become available to the Irish state?
Margaret, before I call on the Minister, I'd like to welcome Mrs. Bridget Walsh, who recently celebrated a significant birthday, her 90th birthday, and she's joined by her family members and their guests of our colleague Senator Imelda Goldsborough. So I take it you're all from Tipperary. Hope you enjoy your visit here to Leinster House today, and congratulations on your recent significant birthday. So, thank you. Mr. O'Callaghan.
Thanks very much, Cathaoirleach, and I want to thank Senator McDougall for his question. I can just state at the outset that I recognise that this is a considerable body of work for the Seanad, the committee stage amendments that are before the Seanad. Senator McDougall mentioned that it was guillotined in Dáil Éireann. That was correct, but there was extensive debate nonetheless at second stage on it. I think we debated for 3 days at second stage, with committee stage, which was truncated, and report stage. Like, it is true to say that not just Ireland, but all other countries in the European Union who've agreed to sign up to the regulations and directives to harmonise systems of migration are under time pressure in terms of trying to get this body of work in place. I believe that it will be to the benefit of Ireland in the long run that there is a harmonised system of asylum law across the overwhelming part of the EU that has agreed to transpose the Pact into domestic legislation. Can I just say at the outset, just to cover myself in respect of future things, that there will be some additional matters that I'll have to bring forward at report stage here, and these include data sharing, matters relating to collection of fingerprint data from applicants, some amendments arising from the new Part 4 on reception conditions and Part 5 on restrictions of freedom of movement and detention, the repeal of Section 20 of the 2015 Act, which deals with detention under that Act, provision for monitoring of accommodation centres, amendments to the Childcare Act 91, Children First Act 2015 and the National Vetting Bureau Act 2012, matters relating to permission of applicants to enter or remain, some minor technical amendments to section 156, which deals with withdrawal of international protection, and clarification of the provisions of the bill relating to superannuation. Senator McDougall raised an issue in respect of his amendment, which is an amendment, I suppose, in respect of section 126 of the bill. Section 126 deals with restrictions on freedom of movement during asylum border procedure. And Senator McDougall's question is, well, how is the asylum border procedure going to be applied from the 12th of June onwards? Like, I can tell him that that process is already ongoing, because since last year, my department has already begun to operate elements of the new asylum border procedure and transition gradually to fully implementing the Pact. This transition is being undertaken within the framework of the existing 2015 International Protection Act. To begin this transition, new Pact readiness teams were established in June 2025. Operations began in City West Reception Centre. The phased approach has enabled my department to test the ability of the international protection system in its entirety to process cases within the required timeframe of the future asylum border procedure and to make adjustments where necessary. This work has allowed my department to identify pressure points and practical challenges across the process to create new standard operating procedures and to set out future training needs. And the type of cases that are being dealt with at present in terms of under the pilot project, which is seeking to implement what the Pact will look like, are applications from safe countries, applications where there is a less than 20% acceptance level. So they're the type of cases that will be dealt with subsequently under the expedited procedures once the new legislation comes into effect on the 12th of June. As I indicated, Senator McDougall's amendment that's been ruled out of order concerns section 126 of the bill. Just so as people are aware that it's my intention that that section 126, will come into operation on the 12th of June. The formal designation under section 126(1) of a premises as a location for the asylum border procedure will be done and operational with effect from the 12th of June. Senator McDougall's proposal that was ruled out of order proposed that there be a positive resolution of each House of the Oireachtas should be required to approve any commencement order. I do not believe that such a provision is necessary, since any commencement order can be made under section 1 of the bill. So that's just a brief answer to Senator McDougall's question. Thank you.
To the Minister for his brief answer, at least for the brevity of it. But as I read section 117, which is the asylum border procedure, the Minister is entitled to apply that.
We're on section 1 at the moment.
Yeah, I know, but I'm just.
Okay.
I think it is relevant. The Minister is entitled to apply the border procedure in the circumstances set out in subsection 2 of that section, and they're the only circumstances in which it can be done. And I'm asking. It seems to me that, with the exception of paragraph A. That B, C and D are not really relevant to the claims made by the government that this is going to massively speed up the investigation and decision-making process, because the asylum border procedure can only take place following an application made at an external border crossing point or in a transit zone. And the Minister has gone on the record to say that the great majority of asylum applications are made by people who have transited into the state via the United Kingdom. And what is an external border crossing? Who are these people who are to be caught by Chapter 6 of the bill? And we're being told that this is urgent and that Ireland has to do this by June the 12th. But this is completely unworkable if it doesn't apply to people who turn up in Dublin, having availed of the common travel area to get in here. And so I'm asking the Minister, to explain to whom the asylum border procedure and the 12-week limit on determining asylum applications as provided for in Chapter 6 is going. To whom is this procedure going to apply? Is it to somebody who arrives up, as I say, at Carrickgarnon, where there used to be a border post, and is foolish enough to apply in that place for asylum? Or is this entirely illusory, and is the public being fed a completely distorted view that this legislation somehow speeds up the asylum procedure, when in fact it will be the speeded up process under Chapter 6 won't apply to people who cross the border, come to Dublin and ask for asylum in Dublin. Is my understanding correct or incorrect on that? Because it goes to the heart of this bill. If the people have been told, which they have been told, that the Migration Pact gives this state the opportunity to dramatically speed up the treatment of asylum applications, and that there will be a 12-week limit, and we haven't even talked about judicial review. But if the Minister is is not in a position to tell this House that the great majority of asylum applicants will not be capable of being dealt with it because they will not have been made an application at a border crossing point. If that's the case, the urgency of this is being spun as a reason to rush it through. But the reality is that the Irish people have been sold a pup. They've been told that this Migration Pact was the answer to all our problems and would speed things up, whereas the great majority of people who travel through the UK, as far as I know, none of them have ever at Carrickgarnon or anywhere else on the border applied for asylum. So, I mean, Alaska Hurlick, this goes to the heart of this. The public are told, here is this miracle solution to all of our problems. Here is a 12-week period provided for. All of these people to whom this procedure applies will be dealt with in 12 weeks, and they won't, because the courts will be invoked almost immediately, I'm sure. But even if you leave out the courts, you're dealing here with a procedure which is not available if somebody just applies in Dublin, on my understanding. And I would ask the Minister, just very, very briefly, to answer a question, yes or no. Is somebody who crosses the border from the United Kingdom and applies for asylum in Dublin, are they or are they not capable of being dealt with under the asylum border procedure? And does or does not the 12-week examination period apply to such people?
To remind members, I'm allowing Senator McDougall to comment on Amendment 2 because it was in his name, but it has been ruled out of order. And the Minister will reply, and then I will be asking that Section 1 stand part of the bill. So
I should say, Alaska Hurlick, that you very kindly informed me that a letter had been sent to me.
It was sent, yes.
It arrived at lunchtime while I was doing other business. That's the notice I got of the ruling of the Chair.
Okay. Minister.
Alaska Hurlick, firstly, I just want to put on the record of this House, lest anybody misinterpret anything I say in the course of the debate on this bill. I don't morally condemn young men in particular from disadvantaged parts of the world who see in Europe the opportunity of a better life from an economic and social point of view. I make no moral condemnation of them, no more than we collectively made moral condemnations of our own nationals who at times in the past went to the United States and outstayed their welcome and became illegal there. I think it's perfectly understandable that these young men in general terms who from West Africa, from the Maghreb, from East Africa, from the Middle East, from Afghanistan, from Vietnam, that people who live in those countries see an opportunity to come to Europe and to participate in an advanced economy, which is that of the European Union, and secondly, to avail of the fact that the state in the European Union will look after them to some extent in a way which other states would not. So I just want to put on the record moral condemnation of migrants, and I use the term migrants advisedly, is not a part of my thought process or my approach. The second thing I want to say is that where the European Union and its member states have put together an elaborate legal construct based on what's in Article 18 of the Charter of Fundamental Rights and Freedoms, namely the right to asylum, where the European Union itself has, and I use this word with a degree of cynicism, has decided that it has a competence in this area, when it is proven generally that it has absolutely no competence in the sense that the ordinary person would give to that phrase. And that where the European Union has created a legal construct which allows people to travel to Europe by one means or another and then to claim asylum, where it does that, it's almost inevitable that anybody who sees an opportunity, even if the odds are against them in the sense that the Minister says that the majority of applicants are now refused in Ireland, but if they see an opportunity to get to Europe and to be one of the people who Senator Keoghan mentioned, the million people who are seeking asylum status in Europe, it's perfectly understandable that they're going to do it. I mean, why not? Why not? It's a good toss of the coin. You're more likely than not, in some circumstances, to succeed. So I don't morally condemn people who see that opportunity. If the Americans, for instance, had a system whereby the Irish undocumented were effectively given a legal channel within the United States to stay there permanently, the flow of Irish people to America in those years would have been huge. They didn't. The Americans are more stern than we have ever been in relation to undocumented people, and now things have got to a really appalling situation with ICE and the Trump administration. So the second thing I want to say is this, that those people who do travel from Vietnam, from West Africa, from the Maghreb, from East Africa, they are part, generally speaking, of a major international racket. They are asked for huge sums of money, thousands of euros, to begin their journey to Ireland or to Europe. They are ripped off systematically by gangsters the whole way, whenever that possibility exists. They are put to, in some cases, terrible risks, like traveling in a container, in which some of them are liable to be suffocated, or crossing the Mediterranean, or crossing the English Channel, in circumstances where their lives are massively at risk, all on the basis that they are paying to participate in this process. That whole migration of illegal migration into Europe is a massive international racket. and it's criminal, and it's wrong, and it is not to be condoned for 1 minute. And the expectations and the hopes and the aspirations of those people who avail of it, that's one set of things. But the terrible abuses of the people who are trapped in this process is another. And that's why I find, I have to say, and again I want to make it clear for the entire duration of this debate in this House, I find that the conflation of migration and the rights of migrants in international law, and the fact that there are international commissions on migration and the like on the one hand, and the people who are trafficked by criminals internationally, the conflation of those two sets of people is very easily done, especially by those who wish to blur the distinction. And that's a point that we find all the time in public discourse on this issue. People, on the one hand, including myself, would point to the positive aspects of migration, economic migration, providing it's lawful, to the role of the Minister's Department and other departments in securing migration where it is needed for our social and economic benefit on the one hand, and on the other hand, the whole process of asylum seeking. And the Minister is talking about the figures that went up and down over the years. I don't want to be unfair to him, but the former Minister, Roderick O'Gorman, who's a member of the Dáil, he told us at one stage, about 3 years ago, that we'd have to get used to an asylum-seeking migration volume of applications of between 25 and 30,000 people per annum. That's what he said. And, the fact that it's down to 13,000 now is good. It's good because the great majority of it, as the Minister has said, is not justified. Let's be clear about it. The great majority of applicants who stay to have their applications dealt with are found not to be entitled to asylum status in Ireland. So the next thing I just want to say, and it is important to say, is that we have a very sophisticated apparatus in this country compared to what I found when I was made Minister for Justice in succession to Minister John O'Donoghue in 2002. At that time, the state was utterly unprepared for the influx of asylum applicants who sought asylum in Ireland. We were unprepared for it. We were defenceless. In many respects, we had not put in place procedures or agencies or the like to deal adequately with the fact that people were claiming asylum. But we have, in the meantime, and let's remember this too, we have spent billions of euros in the accommodation of asylum seekers, the majority of whom are not entitled to asylum. And I have to say that the public rightly asks, what are the procedures whereby some people can become multi-millionaires, providing the state with this accommodation in the circumstances in which we find ourselves. But, and let's be honest about it as well, the High Court, in the very estimable and respectable and highly gifted judge, Mr. Justice Cian Ferriter, has recently had to award effectively damages compensation to asylum seekers who came here at a time when there was no accommodation available to them. They had to sleep homeless. And we all know, we all saw what happened during that critical period. But can I make this point? The average citizen here wonders how it can possibly be that somebody who opts to come to Ireland when there is no accommodation gets compensated for the choice they make. How does that make sense? It doesn't make sense. But it does make sense in one area, and that is legally. And Mr. Justice Ferriter, in a very considered judgment, examines all the case law of, guess what? The Court of Justice of the European Union. And he finds himself driven to the point that the state, which already said, look, we are in breach of an obligation to provide accommodation, but we don't have that accommodation. He says, well, the state in those circumstances must compensate people. And it should be remembered, in that particular case, the state conceded that it was in breach of its obligations. So the real issue was whether the non-availability of accommodation could give rise to a claim of compensation by people who were denied it. I don't know, Minister, and I shudder to think how many other people reading that fine judgment are consulting solicitors around this city at the moment, wondering what they're entitled to for the fact that they spent weeks on the Grand Canal in tents and the like. I don't know what the result will be. But the crucial thing, and this is the point about the Sinn Féin amendment, which intrigues me, and I sympathise with it. The crucial thing is that here we are being told that Ireland is a sovereign state, that we are sovereign. And we are also, of course, members of the European Union. But we have opted into something which very severely compromises our sovereignty. The Migration Pact is a package which further cements the role of the Court of Justice of the European Union in Luxembourg as the final arbiter of what the member states' obligations to applicants for asylum actually are and to what they are entitled to, and imposes its own framework, its own legal framework on member states when administering the law relating to asylum seekers. And that's the point about the Sinn Féin amendment. The reality is Denmark was sensible enough to opt out of a considerable amount of the area of freedom and justice which came in the context of the Lisbon Treaty. And nobody has ever explained to me why it was that when the Lisbon Treaty had brought into effect the Charter of Fundamental Rights of the European Union, why it was considered that the right to asylum was something which the Union could uphold. Why could the Union uphold this? It was a union of member states. Nobody ever applied to the Union for asylum. They were applying to individual member states. And the consequence of I remember the Lisbon debates, and there were all sorts of discussions about everything from abortion to defence to neutrality. Everything was discussed at the time. But nobody said, hold it, what is the European Union doing writing into its fundamental law obligations under the 1951 Geneva Convention? Nobody ever at the time said, this is a disaster in the making, And I have to say, I didn't say it, and I don't. I supported the Lisbon Treaty. I never looked around the particular corner of that right to asylum, because we were told at the time, and this is the important point, we were told at the time that this charter only applied where member states were applying European Union law. And that sounded very attractive as a proposition. You know, if they're applying European Union law, well, right, maybe there should be some charter of fundamental rights and freedoms. But in fact, that situation has dramatically changed. And we now find ourselves, and this is where the Sinn Féin amendment is of interest, we find ourselves now where our sovereignty, to which their amendment refers, has been handcuffed by European treaties to this proposition that the Union, in a flourish of generosity, said, we uphold the European Union, and let's quote it exactly, the right to asylum shall be guaranteed with due respect for the rules of the Geneva Convention of the 28th of July 1951 and the Protocol of the 31st of January 1967 relating to the status of refugees and in accordance with the treaty establishing the European Community. But the simple fact is that the European treaties are supposed to, in fact, determine how the member states operate among themselves. The European Union is not a sovereign body. The European Union is by no means entitled to advance the proposition that all member states must apply this at all times, the conventions, at all times in their dealings with outsiders. And the Minister here said, you know, that he has the difficult role, and I accept it completely, of striking a balance between the rights of would-be asylum seekers on the one hand and the rights of member states on the other hand to look after different considerations. I accept that he feels that, and I accept that he feels he's striking a balance. But apart from the instance mentioned by Senator Boyan of whether we allow family reunification at 3 years or 2 years, and whether that is consistent or inconsistent with European law, and I take the Minister's point. The Minister says that he's advised that the change he's making is consistent with our rights under European law. But apart from things like that, the reality is that the whole migration pact is a further step in the dilution of Irish sovereignty and transfer of that sovereignty to the Commission, to the European Parliament, and to the final arbiters, the judges in Luxembourg, who are accountable to nobody in the end. So when you ask why it is that somebody who comes to Ireland, chooses to come to Ireland to seek asylum, when there is no accommodation for them, becomes entitled to compensation from the Irish people as a matter of European law, by which an Irish judge is bound. The answer is to be found in European law. And I want to say this then, and I'll finish on this point at this stage, that the European Union should not have been given this competence. It should be a matter for each member state to work out where it stands in this issue. It was a mistake to give it to them. And I'm saying this to the Minister. Forget about Ivy House. Forget about Ivy House. When I was Minister for Justice, I was President of the, for 6 months, of the Justice and Home Affairs Council of the European Union. And one thing that I always found was that our diplomats kept on saying to me, if you take that stance, Minister, you'll be isolated. You'll be isolated. And then I used to find when I went to the meetings that the other ministers for Justice and Home Affairs were with me 100%, and there was no question of me being isolated. So the point I'm making is this. I believe that it's time that particularly the ministers for Justice and Home Affairs right across the European Union got together and said to the rest of the European Council and to its president, this system of asylum seeking is not working out well. It's not going to work out well. The Migration Pact is not going to stop what's happening in the Mediterranean or what's happening in the English Channel and therefore across the border into Ireland. The time has come for the European Union to reconsider whether member states' sovereign rights should be restored to them so that the Danes can do what they want, the Poles can do what they want, and the figures that were mentioned by Senator Keoghan were interesting, because if you actually put the figures of applicants per head of the population, we're not doing all that well, I can tell you. We are a destination of choice. But it should go back to the individual member states to determine how they strike the balance. You know, when a state like ours is in the middle of a housing crisis, to say that an applicant for asylum is entitled to be compensated because he has voluntarily come to this country and found there was no accommodation available to him, that offends common sense. He didn't have to come to Ireland. Nobody, no matter what view you take about asylum seeking, nobody is forced to come to Ireland because it's very difficult to get here except through the United Kingdom, and it's even difficult to get there except through France and the rest of it. So what I'm saying is it's about time that the government here looked at Article 18 of this Charter of Fundamental Rights and Freedoms and said to the government in Slovakia and the government in Poland and the government in Latvia, Estonia, Lithuania, and I'm not talking about Hungary, but I'll include them in, and Austria, and Slovenia, and Slovakia, and Italy, and Spain, and France, and the Netherlands, and Denmark, and Sweden, and Finland. And Finland's, by the way, asylum seeking is 2,000 people looking at the Netherlands, and Denmark, and Sweden, and Finland. And Finland's, by the way, asylum seeking is 2,000 people asylum seeking it. And they have the same population as we have, and there's a lesson there. It's about time that the governments of the European Union said that the so-called competence which has been conferred on the Union isn't working out, and that they want a radical rethink on this issue. Now, I'm not parroting or Trump-like views on immigration. I'm quite happy with immigration, providing it's lawful. I'm very happy with it. And I do believe there's a danger that, you know, hard-right, racist thinkers, they equally like to conflate migration. I mean, there's two people who like to conflate migration with asylum seeking, the hard right and the hard left. Truthfully, down the middle, we have to draw that distinction. And I'm just saying that it's about time that the governments of the European Union got together and said to the institutions of the European Union, particularly to the Parliament, which is you know, nothing is good enough for them but to get more power, that the member states would make a better fist of asylum seeking in particular, if their sovereignty was, as suggested in the Sinn Féin motion, restored substantially, and if the European Union admitted that it cannot maintain the cohesion of the Union and at the same time make such a bags of controlling the abuse of asylum seeking, which is an economic and criminal racket operated at great value, at great cost to the people who are stripped of their money by traffickers. It's about time that we actually honestly said that migration is good, bogus asylum seeking is bad, and we will not allow the abuse of asylum seeking to put member states in the position that we have in this country been put in, which is over, I don't know if you put over 10 years, how much have we spent on asylum accommodation? It's 1.3 billion a year, is it? The 1.2 billion a year, you know, that's 12 billion. You can build a lot of things with 12 billion and do a lot of things with that money. But we have put it into the hands of landlords and hoteliers and others around the country to no avail and to achieve practically nothing. And finally, just very finally, there's no justice in putting people into substandard accommodation. There's no justice in that, especially when there are children involved. But what else can this country do when it's pumping resources into the hands of persons who are exploiting the shortage of housing by offering the state emergency housing at unconscionable rents?
Senator Alice Mary